Welcome to the 44th lecture in this lecture series on international investment law. This lecture is a part of the chapter on expropriation. But for a small detour, we have been dealing with compensation for expropriation in the last few lectures. In this lecture, we will deal with the concept of moral damages in international investment law. First, we get the definitional issue out of the way. What is moral damages? Moral damages are damages suffered to compensate for an injury inflicted resulting in mental suffering, injury to his feelings, humiliation, shame, degradation, loss of social position, or injury to a person's credit or to reputation. The legal basis for awarding moral damages can be traced to Article 31(2) of the draft articles on responsibility of states for internationally wrongful acts as of 2001. Article 31 states 1. The responsible state is under an obligation to make full reparation for the injury caused by the internationally wrongful act. 2. Injury includes any damage, whether material or moral, caused by the internationally wrongful act of a state. Commentary to the draft articles provides an inclusive definition of moral damages. It says moral damage includes such items as individual pain and suffering, loss of loved ones, or personal affront associated with an intrusion on one's home or private life. Although rare previously, claim regarding moral damages, in addition to claim for material damages, is increasingly becoming common. It is not only the investor who has sought moral damages in the past, even the host state has sought it. For instance, in Cementonia versus Turkey, Turkey claimed moral damages on account of the investor making allegedly spurious allegations against Turkey and damaging its international reputation. However, Turkey did not succeed in establishing the claim for moral damages, although the tribunal recognized that the claimant had made a fraudulent claim. Now let us move to the question as to the basis for awarding moral damages. Both in Desert Line case and in Cementonia, the general power of the tribunal to award moral damages was recognized. Nevertheless, only a few tribunals have awarded moral damages in the past, and these are awarded in exceptional circumstances. The principle of exceptional circumstances has been recognized in several awards which are provided here. But what are the exceptional circumstances? The phrase exceptional circumstances has been explained in Lemire versus Ukraine in the award dated 28 March 2011, where the tribunal stated 333. The conclusion which can be drawn from the above case law is that, as a general rule, moral damages are not available to a party injured by the wrongful acts of a state, but that moral damages can be awarded in exceptional cases, provided that the state's action imply physical threat, illegal detention, or other analogous situations in which the ill treatment contravenes the norms according to which civilized nations are expected to act. The state's action caused a deterioration of health, stress, anxiety, other mental suffering, such as humiliation, shame and degradation, or loss of reputation, credit and social position, and both cause and effect are grave or substantial. However, this test was not followed by the tribunal in Arif versus Moldova, where the tribunal was of the view that the formulation of the principles of award of moral damages in Lemire was based on limited discussion of three cases, with no broader consideration of underlying principles or policies. The statement might serve as a summary of the issues in these cases, but it should not be taken as a cumulative list of criteria that must be demonstrated for an award of moral damages. The first element, in particular, might reflect the particular circumstances of the Desert Line Projects LLC versus Republic of Yemen case, but the facts of a single case do not define the availability of moral damages as a remedy. In the tribunal's view, the older Lusitania case, the basis of the second factor in Lemire, correctly states the criteria the tribunal should take into account. This leaves the tribunal with an element of discretion, but within the general framework that moral damages are an exceptional remedy. Nevertheless, the Arif tribunal also subscribed to the view that moral damages could be awarded only in exceptional circumstances when both the conduct of the violator and the prejudice of the victim are grave and substantial, thus agreeing with the third criteria in the Lamar Award. Moral damages also require higher threshold of proof. In Qui Borax versus Bolivia, the tribunal held in its award dated 16 September 2015 that had the tribunal entertained this claim, it would in any event have denied it for lack of evidence of any specific moral injury. Indeed, the tribunal agrees with Bolivia and Lemire that the threshold to award moral damages is high. It also shares Bolivia's view that the claimant's case and the evidence on record do not meet the exacting criteria required in order to grant moral damages. In addition, the tribunal shares the opinion of other tribunals according to which moral damages are an exceptional remedy. Some examples where moral damages have been awarded are Desert Line versus Yemen and Want Pezol versus Zimbabwe. It may be noted that typically in moral damages, the violator's conduct is grave and may be directed towards officials of the other party. It is awarded to the party to the dispute, which could be a legal person or even the state. See Oxus Gold versus Uzbekistan, where it was held that legal persons could be awarded moral damages. Now we move to the last question under this topic. How is compensation assessed while awarding moral damages? The starting point is that it is virtually impossible to calculate moral damages with mathematical precision. This has been recognized even in the Lusitania cases. Assessing damages is difficult. Some tribunals may proceed by discretion. In Desert Line, for example, the tribunal employed its discretion and awarded US dollars 1 million, that is in Desert Line. Another tribunal had ordered payment of US dollars 13 million. This was in the Van Pezzoli case. But it was also cautioned by another tribunal, perhaps correctly, that a purely discretionary award of moral solace would be to subvert the burden of proof and the rules of evidence. This was in the Rom Petrol Award. All the awards that have been referred to in this lecture have been provided in the description to this video along with the links. So those interested can access it. Bye bye and stay safe.